the seminar hopefully will give you the information, generally speaking, on what we've seen change over the last year, year and a half. I can tell you this is changing almost daily. So what we're starting to see now is Supreme Court changes. We're seeing key cases, and we'll talk about several of them, going up to the Supreme Court that will be ruled on in the next few months, that will dramatically change some things and some practices you may be engaging in. We're also seeing agency changes, the EEOC, the Department of Labor. And so most of this will focus on the federal level. For those of y'all that are operating in California, anybody here? Got one hand, two hands, I'm sorry. Yeah, that's about what I have to say about that. But, you know, look, there are state law practices that make it very difficult in this area. Most of this is going to focus on federal law, but the state law changes, and some of them will focus on trends that are happening. California is leading those trends, and anywhere where the federal law is going to set the absolute floor for what we expect to see, and each state can ratchet it up a little bit. California is going to be the state that ratchets it up the most. Let's see if I can get this guy going. Sorry about that. So the first thing we're going to talk about is wage and hour law. This is a broad topic, but generally speaking, we're talking about how do you properly pay your employees under the Fair Labor Standards Act. It's not as boring as it sounds, I promise. It's actually not that bad. So primarily, what happened? Anybody who didn't know about this probably has been living under a rock for the last 3 years. But about 3.5 years ago, President Obama, during the State of the Union address, told everybody we need to change the exemptions. They're too difficult, and we can't tell employers exactly how to implement these to understand who is exempt from overtime. And that's really the key that we're going to talk about here. And what happened is who is or is not properly exempt from overtime. So after a year and a half of waiting, we saw proposed regulations, and then they released the regulations that initially told us we were going to see a change in the minimum salary from $455 a week, currently where it is right now, which comes out to $23,500, just over that, to $913 a week, which is a massive jump. We were talking about more than doubling. So you're talking about going to $47,476, but it was updated every 3 years. So that told you, and they sold it as we're giving you a little bit of a break, because initially we proposed to do it at 49, and we ratcheted it down to 47, as if that was a great concession. But what we saw was they said it's updated every 3 years, it's going to be 53 years after. So I went around the country, and I spoke on that all summer, and I told everyone there is no way this is going to be blocked. It's going to be in place December 1st. And just because I told every single person there's no way it's going to be blocked, it got blocked. So November 22nd of 2016, there was an injunction. So there's different types of injunctions, and I won't go into too much detail about what that means. All it meant was, at least initially, it wasn't going to go into place. So we knew for temporarily, we weren't going to see that number. By the way, and this is an interesting fact, some 84% of employers had already made the changes. Every one of my clients had already made the changes. We didn't have a single person that hadn't either evaluated and said, we're just going to pay them hourly and just reclassify them, or we're giving people tons of raises, which is really fun to try and explain how you backtrack that when this gets blocked. But they blocked it nationwide. And the Obama DOL said they're going to appeal. So this was an injunction that was issued in the state of Texas, which means they go to the 5th Circuit Court of Appeals, and they appealed. However, what happened? In January, we all know, January 2017, change in the White House. So where are we now? Well, in June of this year, or I guess June of last year, you'd be remembering it's not 2017 anymore, it's 2018. So in June of 2017, our new Department of Labor said, we still think we're going to appeal this decision. We still think that we have the right to set a salary level that is higher than $455 a week, but we don't think we're going to advocate for the $913 a week. So exactly how clear is that? It's as clear as mud. They didn't tell us anything other than they were going to continue to advocate for the appeal, primarily because the basis of the preliminary injunction was We can't tell you how much is too much, but 913 is too much. So exactly how much can they raise it? If 455 is 23,000 plus a year, then how much is acceptable? And we don't have an answer to that yet. So I know a lot of people have been asking me pretty frequently, where is it going from here? And unfortunately, it's just guessing games. We don't know. In July, after announcing that they were going to appeal, they issued what's called a notice of proposed rulemaking, a request for comments, asking everybody in the public to tell them what is the proper number. 913 is too much. A court has told us it's too much. But what is the right number? And lots of people gave different answers. They wanted to know, what should the salary threshold be? Should we change the duties test? For our California friend back there, in California, you have to perform exempt duties more than 50% of the time in order to be exempt. Where I practice in Georgia, it just has to be your primary duty. So it could be 20% of the time, but it's the reason why you hired that person is to be a manager. And you can argue they're exempt. Well, in California, you lose. So they've asked, should we do something different with the duties test? What about automatic updates and increases? We talked about it just a minute ago. The proposed rule that was to go in place December 1st had an update every single 3 years. A lot of us, myself included, believe that that's not lawful. Every increase, in my opinion, requires a comment period. However, it passed and was to go in place prior to the injunction. Crediting extra compensation. This is your bonuses, your commission. How much can they count towards your salary threshold? And the biggest question they asked, which there's a lot of people torn about this, is should we have different salary levels depending upon where you work? So should it be different in Georgia, in Mississippi, in South Carolina than it is in New York? Because it's a very different demographic, and you have people earning different amounts. It's a great question. We don't have an answer to it yet, but we will sometime soon. Here's my personal view on that. I think, and of course don't hold me to this because I was wrong on the injunction, so we all know I have a tendency that might be wrong. I think it's very unlikely they're going to be doing geographic differences. It becomes a huge headache for people operating in different states. So you might have people in the same positions that could be exempt in one state and not in another. We already have that issue with state law. If you made federal law compounded, we'd be having somewhere between 7 to 10 different tests you have to look at just to determine if someone's exempt in each state. So August 31st, the judge struck down the overtime rule on a permanent basis. We talked about the initial temporary injunction. This was summary judgment. This means the judge says, you lose, end of case. It really did nothing different than the injunction. It just made it a little bit more permanent. And then we waited to find out would the DOL appeal. There were a lot of people saying they might not, based on the presumption that they wanted the rule to die, since they had already issued a notice of proposed rulemaking saying, we're going to change it. We just don't know what we're going to change it to. They did appeal to the Fifth Circuit, but they asked for a stay. So they basically have said, do not do anything on this case. We want to be able to decide what we think is proper first, and then we'll probably dismiss our appeal. So it's a whole lot of background to take us to where are we right now today. And the answer is, we know that something is coming. There is a notice of proposed rulemaking that will be issued changing the salary. They're not going to leave it at $4.55 a week. They've asked these questions. Most likely you're going to see somewhere between 30, 35,000 as the figure. It's pure conjecture. It's just based on what we've been hearing in chatter out of the Department of Labor. But you're going to see them increase it. What I think you'll see is you'll see them increase it and probably increase it over a period of years. So rather than it being automatic, they likely will step increase. So you have a year to go up 5,000 and another year to go up 5,000 until we get to the figure. We currently see on the Department of Labor's website that they intend to release the rules in October of 2018. Anybody that's sat around and waited on government deadlines before knows that they're probably not going to hit that. They're not so good at hitting their proposed deadlines. So what I would anticipate is it'd be really nice if we saw something before the end of the year. But I don't be surprised at all if it's 2019 before we see the proposed rule. All right, so what else have they been up to? There have been a ton of changes internally. So we have a new Secretary of Labor, Secretary Acosta. Secretary Acosta immediately changed a lot of the leadership. How many folks, just by a show of hands, I'm not going to call on you, have had to deal with the Department of Labor audit where they show up and want to investigate you or any of your employees? All right, we've got several folks. Supposedly, and we haven't seen it yet, but supposedly they are ramping those down and they are increasing training. And the idea being that they're more focused on compliance than they are on enforcement. In the 1 year that I've been dealing with, or less than a year total since Acosta's been in office and the Secretary of Labor, I have not seen it yet. We still are seeing a large number of Department of Labor audits. They still are showing up without any notice, asking for your time records, asking for your pay records, and asking to speak to your non-management employees right away. The only advice I have to you on those is do not just let them talk to people, call your attorney. There are just so many problems that can happen the second they open that door and the second you hand them the records. They don't have a right to tell you you can't call someone. They can tell you they want the records now. The reality is no one has, at the push of a button, immediate access to everything they want. Tell them you'll get them to them in 48 hours. That's reasonable. They will allow you to do that and push it off until you can talk to somebody because there's just so much liability that can come with one of those investigations. They, a really welcome return for most employers is wage and hour opinion letters. It sounds like something small, something not that big of a deal, but for the last 5 years we have not had wage and hour opinion letters, which means you can't ask a question to the Department of Labor, whether anonymously or under your name, and get an answer. Hey, this is the situation we have, we're paying them this way, is this right? They took that away, it's back. Generally speaking, it's not widely used. It's not the kind of thing you're going to ask, hey, I just want to, I have a payroll question. I want to send it in. And the biggest reason why you wouldn't is it takes them 6 to 8 months to respond at the earliest. So it's not like you're going to get a timely response. But if you have a detailed question about how you're paying someone, the Department of Labor will give you an answer and you have a right to rely upon that answer. So that's back. Key in allowing those to return is they reinstated several wage and hour opinion letters that were withdrawn in 2008. The two key ones that relate to your field relate to superintendents and people running jobs. And they both say that if your primary job is to run the job, even if you're not supervising your own employees, if you're supervising a contractor, you're supervising a sub, or you're supervising a job that other people's employees are working on, you can properly classify those people as exempt. They are, of course, very fact-based, and so I'd encourage you, if you have a question about those, to read those letters and make sure you consult with counsel. However, that's a huge return for employers that was taken away, and the Department of Labor, in my experience, was ruling that superintendents that do not supervise your own employees were not exempt over the last 8 years. So it's a nice change and something you can argue on. Increase in the federal minimum wage. We hear about the fight for 15 all the time. Federally, I do think we'll see a change. $7.25 is just a pretty low minimum wage that hasn't changed in years, but I don't think we're going to see anything near $15 an hour. I think you can be pretty comfortable knowing that the change is going to be incremental and it's going to be slow, and I'd be surprised if we get anywhere higher than $8.50 or not. We talk about cause and effect, federal versus state. You see on my slide, California employers, I'm sorry. But generally speaking, if the federal government doesn't act, what happens? States that want changes act. So we've seen it in Illinois, we've seen it in California, we see federal minimum wage, we've seen it in New York. Federal minimum wage is unacceptable to states, and so they push for higher minimum wages. So California is incrementally increasing, New York is incrementally increasing. We saw Arizona increase this last year. We're seeing a lot of states say, well, if the federal government isn't going to act, my state is. So keep in mind, if your state, if you live in a state that wants to act on that, you need to either yourself or have someone in your business responsible for understanding when do those changes go into effect and how is it going to affect me. It's as simple as knowing when the minimum wage laws change, but it's critically important because nobody wants to get hit with a minimum wage lawsuit. All right, another big change that we've seen over the last year, immigration law. So, the Trump administration immediately announced that one of its primary focuses was going to be an update and change on immigration law. We saw that southern border crossings had decreased. H-1B annual visas declined for the first time in 5 years. That's a crazy figure, by the way. So we anticipated them continuing and continuing to increase. To see that go down is a huge, huge change. And so what it means is the ability of employers to bring in what are perhaps qualified, but arguably difficult to bring into based on the visa standards employees is changing. It used to be a deferential standard where you were probably not going to be questioned that hard on your visa application. That has changed. So if you want to bring someone in on a visa, make sure you have solid basis for it and you are comfortable with the visa process, because it's the kind of thing now where, number one, they're challenging people, and number two, they are going after people who are making statements that they believe are false in the visa application process. There has been a ton of confusion about this travel bans that have been implemented. There is a travel ban in place now. It is country specific. The Supreme Court is still going to hear it. However, what they said was they struck down the first travel ban, there was a second travel ban, there's actually a third travel ban in place now that is country specific, and they said we will allow this one to stay in place in a limited fashion until we hear it. So there is, for all of the talk about it you see in the media, I feel like between the sexual harassment movement that we've seen explode in the last year and the immigration movement we've seen in the travel ban discussion, I think those are probably the two most popular topics that we hear about from the main media, and maybe not are the most pressing issues that you're dealing with inside your office. But they're certainly the ones that, if you just listen to the media, you would think these are the biggest issues. Last year, we got a new I-9 form. This is critically important with the focus of the Trump administration on immigration. I-9 compliance and I-9 audits are something you have to be doing. You have to make sure you're using the right form. Just using the wrong form is a fine. And every minor violation, when you think about, hey, we put the wrong thing in the wrong box, or we forgot to fill in one part of the form, they have the ability to fine you on every single I-9 for every single mistake. They typically are not going to be that aggressive. However, you don't want to put yourself in that position. Why risk it? Make sure you understand the I-9 requirements, and make sure you have someone who's in charge of maintaining them. And there's a ton of confusion, you do not have to keep copies of the records. You do have to keep copies of the I-9. So if you are not maintaining I-9 forms separately in an I-9 file, start. This is going to be an area where they are absolutely going to be hitting on more and more over the next few years. All right, mandatory E-Verify. So
Real quick, on the I-9, do they all need to fill out new forms? Like, should I have all?
No. So only thing that's required is new employees use the new forms. In an audit, and that's a great question. The question was, do they all need to fill out new forms? In an audit, if you find a mistake, it should be fixed. And it should be then initialed with today's date or whatever date that you find the mistake and fix it. So it's very clear that wasn't the original. You don't want to make it appear as though the document has been changed or forged or is incorrect. You want to be very upfront about the fact that it was changed based upon an audit or a review. But when they change the forms, all that means is moving forward, you have to use those forms now. And do not go and change or force employees to go through the I-9 process. That's actually illegal as well. So you can't win one way or the other. Just like mandatory E-Verify. So it's not mandatory in every single state, but I can tell you it's mandatory in a lot of states already. So it's required in Georgia. It's required in many states around the country. Having said that, there's still a few holdouts. If you are a federal contractor or you have any federal jobs of significant money, I'll say $50,000 or more just to make it simple. There's different tiers for different things. You are a federal contractor that's going to be required to E-Verify. So if you're not using E-Verify, go ahead and do it if that's the situation. How many people in here, just by show of hands, aren't using E-Verify? So we've got a few. My personal opinion is it was a very flawed system about 10 years ago. They've made a lot of changes to improve it, and I think it's something that voluntary compliance with used to sound insane, and I would say now it's not a bad idea. It's a system that is simple enough and has enough self-training on it, on the website, that it's something that makes sense if it's coming, so that you're well prepared. Yeah, we got a question.
We use a PEO and do the employee leasing thing. How much of the I-9 stuff do I, as the employer, need to worry about?
So your PEO is probably doing that.
They are.
Yeah, I was going to say, so it's one of your responsibility. The problem is if they're not doing it right, it's both of your problems.
Okay.
It's not just their problem. However, as long as you're comfortable with their process, and I would ask them about it,
Okay.
then that's sufficient.
Okay.
So we also have seen what we anticipate. We say extreme vetting of visa applicants. This is basically a way of saying they're cranking down on visas. There simply are going to be less and less visas available. You're still going to see H-2A, so you're still going to see a lot of agricultural workers come from visa processes, but other than that, the visa process is going to be substantially changed. We still don't know with RAISE, with DACA, if there's going to be a resolution. They're still talking about it. I mean, literally, I feel like you can't turn on the news and you not hear about it today. Having said that, it may just hang out there for 6 months or a year with continuing proposed budgets just to keep us going and without a resolution to what is going to happen there. So for the moment, just keep in mind, you're responsible for making sure that your employees are authorized to work in this country. And if you're employing someone that isn't, it's potential liability, and this is an area of focus in this administration. All right, pay equity. Huge change over the last few years. So essentially, the EEOC said you were going to have to give pay data on all of your employees based on position, gender, and based on protected category starting this year as part of your EEO1 process. And it was going to start, obviously, at 100 employers with your EEO1 and crank down and begin to start affecting in years to come smaller and smaller employers. Why do they want this data? Why do they care what people are paying based on their EEO1s? The answer is they want to use the data against you when someone sues you or files an EEOC charge. They want that data so that it can be statistically driven in lawsuits. So about 6 months ago, they announced that at least for the moment, the EEO1 rule, which was going to require you to share pay data based on gender, is stayed. Having said that, the EEOC has said it's not gone. They don't know what they're going to do with it. So anybody that was planning on complying with it, that might not have been a bad idea. It still may be put in place in some form, but the form that was proposed is not going to be the form that actually goes forward. For those wondering, a lot of employers had no issue with sharing pay equity data. However, in the form proposed, it was incredibly burdensome to produce that data. Their anticipated compliance time, according to the form, should take between 45 minutes or an hour. Well, I sat down with a client and we engaged in a proposed version of the EEO1 just to test that, and it took about 5 hours, and that was with my help. So you can see why a lot of folks said you don't understand what you're asking employers to do, and for some smaller employers, incredibly burdensome where this data is not immediately available. So that has at least temporarily been blocked. So we talked about in the federal world for the Fair Labor Standards Act, what do you see when the federal government doesn't act? States act. You're going to see some consistent patterns amongst things we talk about. So if the federal government isn't requiring people to do this, some states are. California passed a new Equal Pay Act law 2 years ago. New York passed one this year, and several states have proposed versions of it in place that could be passed in the next year. So what are these laws doing? Essentially, the federal law, we already have a federal law on equal pay. It's called the Equal Pay Act. And it says that you have to pay people the same amount of money if they are doing comparable jobs and if they are comparable in terms of experience, in terms of what they came to you with, how they got to you, years of on-the-job experience with you, years previous resume, all of the things you would normally look at when you're trying to decide what you're going to pay someone. The key here is who is looking at the same job. What is the same job? You know, location A versus location B. I'll use California as a good example. So San Francisco is going to be different than Burbank. It's going to be different than Los Angeles. There's all these different markets that pay differently. And in California, they basically have said, your comparisons are a lot narrower. You cannot make these broad changes and say, well, I'm just relying on they're doing things a little bit differently. So they flip the burden on the employer to affirmatively show that these people are engaging in very different job duties. It makes it much more difficult to defend a lawsuit like that. And following up on that, what we've seen in Philadelphia was the first city to propose it, and we are seeing it in states now. The idea of relying upon prior salary is no longer accepted. And so the states that are saying this and the cities that are saying this are saying the idea of pay discrimination has been around for years, and if you rely upon someone's prior salary, you're perpetuating previous pay discrimination in your own hiring practices. It's really hard to implement in practice, but essentially, the laws are saying you should not be asking about salary history in your application anymore. So, if that's in place in your jurisdiction, you have to change your application, or on its face, it's strict liability, you're violating the law. If it's not in place in your jurisdiction, the question is, do you want to change it anyways with the anticipation that this may be coming? So there's a lot of things you can ask. You can still ask, how much money would you like to be making in this position? What's your anticipated salary or your anticipated wage rate? And take out the what did you make at your previous employers. I have a lot of clients that have said, as a matter of just simple practice, it's going to be easier to change it now than it is to be forced to change it scrambling in the future. So we're going to go ahead and implement it over the next 6 months. I have a lot of clients that have said, I'm not going to change it at all unless they make me. It's just preference at this point, but just know this trend is coming and it's not going away state by state. So, as I mentioned, I practice in Georgia. It's not coming to Georgia anytime soon. So there happen to be the southern states that simply do not stray from federal law. But there's a lot of states that do. And so if you're in a little bit more of an aggressive state, you've got to be very aware of these laws. So we mentioned revising your application. Hiring materials. This is critical because it's not just what's in your application, but it's what is the hiring manager asking these people in the interview. And that's not on paper. So it's critical that your training materials explicitly say not to do it if you're going to implement that policy. It's a great way to defend a lawsuit when someone says, they asked me this question, to say, no, they wouldn't have done that. They went through a training and here's the training materials on it. So obviously it's still a he said, she said, or he said, or she said situation. It doesn't really matter. If you have an extra bit of evidence to defend you, you're in a much better position. We talked about training. Conduct a privileged pay audit. What does this mean? This means getting an attorney in to look at what you're paying people to find out if you have a problem on the front end. Why do you want the attorney to do it? And even if you're doing it internally and just CCing an attorney on the emails, why? So that it's not discoverable. If you get sued for this in 2 years and somebody finds out you didn't change your pay practices, but you found a problem 2 years ago, the act goes from something that was unintentional, but simply a pay difference, to an intentional act, which can change damages substantially. So you want to make sure when you do, whether, yeah, we got a question.
But that's only if the law is enacted in your state, right?
Well, so pay audits, Equal Pay Act exists everywhere. Federally speaking, you cannot pay people substantially different if they are comparators. Now, that's the critical thing is, who is a comparator? So in order, and I defend these lawsuits every day, in order for someone to establish that they are a comparator as a plaintiff who is trying to sue you, they really have to show I had the same experience, I had the same background, I had the same education, I had the same skill level, and you paid me less. And one defense we hear about all the time is, well, the other person negotiated a higher salary. They came in and they demanded more money, and that's why I paid them more. That is not a defense in a federal Equal Pay Act case. You still lose if that's the basis of the pay. So that's the kind of thing you want to look at, only to understand from a federal perspective or from a state perspective, if you're dealing with even stricter laws, why are we paying people the way we're paying them? Do we understand? Is there a legitimate basis? Can we articulate that? Because a number of the lawsuits aren't losers because you're wrong. They're losers because no one has any idea why people are paid what they're paid. And that's a problem.
But it's, if you have it, so I was thinking more about having it on your application what your salary is.
Yeah, so the privilege pay audit is really conducting a review of your pay practices, not what is on your application.
Okay.
Yeah, those are two different things.
Okay.
Yeah. Sorry. Okay.
You're only comparing what you're doing in your company, not what another competitor is paying your people.
Correct.
Or paying people that do the same task.
Correct.
What was the question?
So the question was, the audit should focus primarily on your people, not what competitors are paying. What competitors are paying is a legitimate basis for you setting salary levels at a certain level. We conducted a audit and review of pay practices of 5 competitors, and we determined that this is the average pay, and that's why we set it this way. That's a completely objective, reasonable basis. But that's not the basis of your review.
So to be clear, if I come to you and there are 3 of us that are in basically the same position, I come to you and I say I need more money, I negotiate a higher salary, you need to bring the other 2 people in the next day and say you just got a raise?
So in practice, and the difference there is post-hire versus pre-hire, which makes a big difference, but negotiating a higher salary based upon some objective factor, including negotiation, you can use negotiation plus, as I like to say it. You can use, they wanted more money because of this, and we decided it was justified because of this. And the 2 different factors together can form a legitimate non-discriminatory reason for higher pay, but the negotiation on its own cannot. So it can't simply be, well, we can't lose anyone, so we'll have to pay that person more and not those people. Okay, we got one more question?
So if I got 3 operators all doing the identical job, one's been with me 1 year, one's been with me 9 years, do I have to pay them equal pay?
No, so it's a huge difference in experience with you, and of course skill level, understanding your expectations. So the question was, if I pay someone who's been with me 1 year versus 9 years doing the same thing, do I have to pay them the same amount? And the answer is no. From a functional review, more years of experience with you, your understanding of their skill level, your incremental raises based upon where they've been, the person for 9 years could be paid more. Where you run into a problem is the reverse of that, where you have, I'll give you an example, where a female has been working for you for 9 years and is making $2 less than the person that was just hired, and that individual that was just hired has the same background and experience as the female that's been working for you for 9 years, that's a problem. And you're going to want to make sure you review that. And there's nothing wrong with making changes. It doesn't admit that there's some problem. It's just a review, and conducting a review with a change afterwards can often avoid a lawsuit. All right, so let's talk about some workplace safety developments. We are talking about OSHA here. So for anyone that doesn't know, in May of 2016, OSHA released some of the silliest rules I've ever heard of in my life. They said that you cannot mandate drug testing after an accident. And the reason they said that is they said that it would chill the reporting of accidents in order to mandate drug testing, because people would be less likely to report it if they knew they were drug tested afterwards. My common sense response is, well, maybe you shouldn't be on drugs and get in accidents, and then this wouldn't be a problem. However, the OSHA rule essentially said that could be viewed as retaliation, and that could be viewed as a chilling act. They also said you cannot mandate immediate reporting of accidents. You have to make it a reasonable period of time, such as 24 hours. That, I think, is more understandable than the drug testing rule. Safety incentive programs were targets of this rule as well, saying the idea that there are incentives for avoiding reporting of accidents for a certain number of days in a row means that people aren't going to report accidents that occurred. Again, at least I can understand where that's coming from. Going back to the drug testing rule, I cannot understand where that's coming from, simply because if you get in an accident, I think everybody typically understands that any significant accident that's reported probably is followed by a drug test. That's pretty common practice in the industry. So,
What about like auto accidents?
and I'll go through kind of where we're at now. That was just the proposed part.
Gotcha.
And that was proposed by the prior administration. Some of this has changed, some has not. So, the electronic reporting requirements, this is your 300A logs. This is your logs of injuries that occur. That was stayed. They're going to do a phased compliance that starts this year and then continues after they ask for comments from the general public about what they should do for larger employers, understanding the burden of electronic reporting that might come into play when you're dealing with 10,000 employees and the number of injuries and 300-day logs that go into this. The anti-retaliation provisions, which, if we go back real quick, were related to mandatory post-accident drug testing, immediate injury reporting, and your safety incentive programs. They're in place. They were not stayed. So let me give you the common sense, because what they said in the proposed rule and what they said as it has been implemented does not make any sense. What does make sense is if the accident is something that plausibly and reasonably could have been caused by either alcohol or drug use, then drug test for it. You cannot be in a situation where you're allowing individuals to have access to heavy machinery, company cars, forklifts, anything of this variety, and not engaging in reasonable action afterwards to make sure you're keeping your employees and the general public safe. Even if OSHA viewed it as a violation, I would much rather deal with a single issue that I'm trying to defend based on my reasonable belief than I would like to deal with a lawsuit, someone claiming that my employee was using drugs, was driving, and injured them. And you're dealing with what they call respondeat superior. You don't want to be dealing with that. So use common sense in this rule. So the one example they gave in the rules as they were proposed was that if an employee reports an injury resulting from a bee sting, they should not be drug tested. I don't know about you, but I have never heard of an employee reporting a bee sting injury. As soon as that happens, good example of something that maybe you shouldn't drug test for. But in the real world, we don't see that. We see significant accidents that cause damage, and I am okay with the idea that objectively and reasonably we believe that that person could have been affected by either drugs or alcohol. And immediate drug testing is acceptable.
Question, if you lease your employees, do you have to file in your leasing company, or is it up to your leasing company to file?
File the electronically?
Yeah.
So it's very similar to the I-9 issue, and the question was if you have leased employees, is it your responsibility or your leasing company's responsibility? The answer is it's one of you. So you got to have that discussion on the front end. You cannot contract out of your own responsibility for it, and neither can they. So you're both going to get sued if it doesn't happen. So have a plan in place and have that discussion. That's the kind of thing where you do not want to be caught without having discussed it with, whether it's a PEO or whatever it is you're using, without having discussed it at some point before July 2018.
It says high-risk industries. I'm assuming we're all high-risk.
You're correct, yes. Yeah.
What about leased equipment? If another employee was injured on your equipment, who's filing on that one?
So usually that would be whoever is the employer is filing on that. I can give you some examples where it comes up that it's an unusual situation where the injury or accident is caused by a problem with your equipment. You see this sometimes in cases that are called combustible dust, where dust catches on fire and creates fireballs. Really scary stuff. And it's really hard to tell who's responsible for it, but employees get injured, so most people file on it. But if it's the kind of thing where it was just an accident, but they're using your equipment, that's probably going to be their employer's obligation.
May I have a question? It seemed as though there was a loophole in the last series in that an employee, let's say, is drunk, legally drunk. He gets in an accident. He finesses the police, perhaps, and gets to wait 24 hours before he tells you about it. Now he's no longer drunk. Is that accurate?
Yeah, I mean, there's still a situation, and of course it relates to the combination of the two rules, the mandatory immediate post-accident reporting versus some reasonable period. My best advice on the way around that is to say as soon as practicable, and then you can say, well, 24 hours later you were capable of reporting it sooner than that, and you didn't. Having said that, if somebody doesn't report it for 24 hours, but the police report indicates that they were drunk, you can take action then. And so that's a whole different question about using arrests and using the difference between arrests and convictions. And the EEOC strongly dislikes use of arrests. What I rely upon rather than the arrest is the action that you believe occurred. And you can question the employee and you can say, I didn't think they were telling the truth. I talked to them about it, they appeared to be lying, and that's why I'm taking my action. And so that's kind of your end around. Right, and so, again, the takeaway, implement and enforce these policies and train your managers on them. We already talked about, right here, the immediate reporting of injury. Reasonable amount of time, I'm fine with that. Just have in there, you expect it to be as soon as practicable, but no later than end of their shift. No later than 8 hours later, whatever that may be. The safety incentive programs, you still can have them, and they've actually kind of changed their position on this a little bit. They should, however, be related to conducting safety meetings, conducting trainings, things like that, instead of the number of days in a row without accidents. All right, so what's going to happen in the notice of proposed rulemaking that is going to be issued for 250 plus employers? It's anybody's guess, but I would tell you if they implement the electronic filing on July 1st, then this is going to happen. And you're going to see that bigger employer proposed rule as well. Anti-retaliation, they have survived and they are in effect. Everyone's favorite topic, medical marijuana and recreational use of marijuana. So another state by state, very, very different view. Whether it is legal recreationally, legal medically, decriminalized, or simply remains illegal. Those are 4 different options. You can see here the states that have medical marijuana. All right, so what do you have to do if you're in a state where medical marijuana or recreational marijuana is legal? Well, the number 1 rule is just because it's legal doesn't mean you have to allow it. There's a huge difference between those two. And then the idea that someone could go out on a lunch break, go smoke marijuana, and then go operate heavy machinery, or go operate in a safety-sensitive position is crazy. So do not allow that to happen, and make sure if you have some belief that it's occurring, you need to be taking action. If your state allows for reasonable suspicion drug testing, you need to be doing it when you have a belief that it may occur. You're much better off, just like we were talking about with OSHA, much better off trying to defend one person complaining about being drug tested. And why do they complain? They complain because they failed the drug test. Nobody complains when they pass the drug test. So you're much better off dealing with that than you are with an employee who you think is a problem that is causing a lawsuit. Yep.
And because federal doesn't recognize.
Yeah.
marijuana.
Yeah.
If we're running trucks that require federal motor carrier laws, that overrides all that.
Absolutely. So
What's the question?
is federal law related to federal motor carrier trucks. and federal law not recognizing the legality of marijuana. We're going to talk about that in just a second. But
Technically, that would be on federal roadway, in your state.
absolutely, and all of your, and by the way, going back to the OSHA requirement as well, all of your, whether it's your federal drug-free workplace or your state drug-free workplace policies, if you're in a program, those trump any of those. So you are allowed to continue to have your drug-free workplace. Absolutely.
Now, what if they come into work just before they come into work, they start toking? How do you?
So the question is, how do you deal with it when an employee is smoking right before work? And if you have a reasonable suspicion, I smelled it on them, I saw it, them get out of a car and smoke was billowing out of the car when they got out, so they were hotboxing the car or whatever it is that's going on. If you have a reasonable belief that that was occurring, you can drug test. And check your state laws to make sure there's no ban on reasonable suspicion drug testing. But federal drug testing requirements, if you are a federal drug-free workplace, trump that, and you have the ability to rely upon it. All right, so what about off-site use and positive drug tests? So, huge area of debate, and we're continuing to have these fights. But the question is, what happens if you are in a state that protects your right to engage in activity outside of the workplace that is considered lawful? So the state of New York has a law that says, as an employer, you cannot take action against an employee if you see or know that they're doing something outside of work that is lawful. What if there's one of those laws and the state allows them to smoke marijuana? We have a ton of decisions from around the country that have said you can still enforce you can't work here unless you can pass a drug test policy. Now, I also have a ton of employers who say we would have no employees if we have that policy. And that is a recognition of today's workforce, unfortunately. So if you are in one of those situations, make sure you're being smart about it. But for the employers that want to say you cannot do this, we have a drug testing policy, and if you violate it and we find that you tested positive, you can enforce that. And the key with the medical marijuana, and this is where it came up in Barbuto and where it was ruled differently in the other states, the ADA, the Americans with Disabilities Act, says that you have to provide a reasonable accommodation to an individual with a disability, as long as it does not create an undue hardship. Well, all of these states said that your use of medical marijuana creates an undue hardship. That is not a reasonable accommodation to be allowed to go smoke pot. And then we have the Massachusetts decision from this year, which is the most outrageous decision of the year. It is groundbreaking. It completely changes the analysis. If you are in Massachusetts, you need to know this case. If you're not in Massachusetts, I do not see any other states likely following suit. But essentially what happened is an employee tested positive. The employee said, it is my medical marijuana. I use it for a purpose of which I have a disability. And the employer said, I don't care why you use it, you're fired. That's against the rules. And the court said, hold on, you didn't engage in the reasonable discussion about whether someone is entitled to an accommodation or not. You didn't engage in what they call the interactive process to find out what's your disability, why do you need this, how frequently. And they said, it's entirely possible that the person only was smoking once every month. And it was, when they were out of work or something like that. And they said, you had to do that before you said no. So they didn't go so far as to say that person's allowed to smoke marijuana, but they also didn't say you're allowed to say absolutely no. So if you're in Massachusetts, that is the lone state decision we've seen so far that has come out this way. Yeah.
But what if you're a federal drug-free workplace?
So what this case was based on was state law.
Okay.
I think if it came out in a federal court in Massachusetts, the employer would have won.
Okay.
I think it's a key difference. We now have recreational marijuana use. So we have 7 states and DC that have passed a law permitting recreational use. So we've talked about zero tolerance policies and practices. You still can have them. I'm still comfortable with them as long as you're doing it in an understanding way. So I don't want you to walk out and simply say, yeah, we got a question.
Oh, we can finish.
No, it's okay, go ahead.
Is it okay to have different laws for office staff and for people that are driving trucks?
Depends. It's a good question. The question was, can you have different laws for office staff than people who are driving trucks?
I ask because I operate in DC.
Yeah, so, and the answer is, if your laws or if your rules are simply based upon company policy, we're gonna have this type of drug testing for employees that are new hires. If you're a driver, you have to, take this drug test. If you're not, you don't. Then in most states, and I don't know DC's rule on that, if your Drug-Free Workplace Act would allow that. However, in most states, that's fine. Where you get into a problem is if most states offer a discount on your workers' compensation insurance if you engage in certain types of drug testing. And if you are relying upon that statute to get a discount on your workers' comp insurance, and you're not testing everybody, then you're asking to get audited and for them to come back and take back every discount you've been awarded. So keep in mind, you can't set separate rules if you're relying on federal drug-free workplace or state drug-free workplace that mandates testing. You still have to do it. So what are we seeing from a federal level? And it's the point you were making. So first, in 2016, we saw Attorney General Sessions say good people don't smoke marijuana. Then in 2017, it remains a violation of federal law to distribute marijuana throughout any place in the United States, whether state legalizes it or not. And then January of this year, just over a month ago, the Department of Justice was authorized to ignore state law and enforce federal law. So we don't know what this means yet. All we know is in California, the federal government could choose to start enforcing it. I don't think they're going to do it in states where it is as widespread as you see in California and Colorado where they've made it recreational. The problem would be the manpower required with enforcement would require the entire agency. However, they might selectively pick one or two places to make a point. So all this means is for all the states that have legalized it, it's now been reiterated that it doesn't matter what the states do. This is under federal law. It is a scheduled illegal drug, and it maintains that status. All right. Yep.
Is it interstate federal property?
So the question was, is interstate federal property? And so it's a wonderful question. So the property itself and ownership of that property is owned by the federal government. What you talk about, what you're essentially getting to, is the Federal Motor Carrier Act, which is they have jurisdiction and authority to set the rules of anything that is safety affecting that travels across the highway. And that's where you start talking about vehicles and testing for people that drive vehicles and things like that, particularly 18-wheelers, where there's very strict drug testing requirements. If someone, for example, if someone falls under the Federal Motor Carrier Act and refuses to take a drug test and they drive an 18-wheeler and have a commercial driver's license, they typically are banned from driving, and it's a mandatory reporting offense, even if they don't test positive, just if they refuse to. So that's where you see a much more aggressive stance. All right, so what did we see in the 2016-2017 term? And I normally would go through all these things just to make the point that it's a yawn. So other things we expect to see soon that we have not seen accepted for cert by the Supreme Court yet. Does Title VII cover sexual orientation? This is a critical issue. There is now a split amongst the circuits. The Seventh Circuit became the first circuit to rule that Title VII could cover sexual orientation. Everywhere, pretty much everywhere, based on the Supreme Court case from several years ago, the idea of gender stereotyping is protected, which means I treated you differently because you don't act like the typical male or like the typical female. That is protected by Title VII. However, a direct sexual orientation case under most circuits is not protected. That case, the 11th Circuit ruled this year, which 11th Circuit is Georgia, Florida, and Alabama, ruled this year reiterating Title VII does not protect that. That case was appealed to the Supreme Court, and they said, nope, not yet. So we know it's coming, it's inevitable because there's a circuit split, but it's not this year, or at least not this term. Another key issue, can states force union members to pay agency shop fees? We expect that to be coming up based on the circuit split. I am going to run through some of this a little bit quicker just so that we make sure we're going to get y'all out on time. But critical to your industry is the idea of joint employment and the idea of independent contractors. So for essentially 6 years, it really was a focus starting in 2010, we saw there was a huge push to essentially hold anyone who has control over an employee as a joint employer, and the idea of someone being an independent contractor, essentially the Department of Labor pushed an idea that it's almost impossible. And federal courts pretty universally did not accept that standard except for the Fourth Circuit. However, we were dealing with a huge number of different tests. So this talks about IRS has their view, Department of Labor has their view, NLRB has their view, state law creates their own view on exactly what is it that makes up, get it? The critical functions of joint employment and misclassification as an independent contractor. What it really came down to, and this was the critical issue, is who controls the employee. So then in September of 2011, we saw the Department of Labor issued their initiative that said, essentially, it's really hard to be an independent contractor. If you're employing someone and you have, and they gave us all these different factors, but they basically said, if you've been employing them for a long time, if they primarily rely upon you as their source of income, if your advertising pushes for them to get more work, because they're doing the work that you receive. They said that sounds a lot more like an employee than an independent contractor. Having said that, none of those factors are who controls what they do, which was the critical component we'd always been looking at for the last 40 years. So it was a dramatic change into what they believed was the standard for who can be an independent contractor. And as it says here, government said, you're pretty much always an independent contractor. In June, that guidance was withdrawn. So we now know that the Department of Labor and the NLRB are focusing much less of their resources to the analysis on this. That used to be the first question when they showed up, was give me your payroll, give me your time records, give me your list of all independent contractors. It's all on their list of what do I need right now. I haven't seen them stop asking for it, but they're not focusing on it on day one, which means they care a lot less about it. That's very good. Problem, courts, attorneys, investigators, well actually good thing they can't look at it, but they can still proceed with the claims. And we're still seeing those claims. There's one attorney in Georgia that's gotten real creative and is trying to bring private suits under IRS provisions. I don't think there's actually a legal basis for it, but in a threat and in a demand letter, you have to deal with it. So that's the kind of thing you want to make sure you're looking at. How are we classifying our independent contractors? Who is an independent contractor and why? So we've seen proposals for legislation to completely change the analysis back to what it was. They haven't passed yet, but there is proposed legislation in place right now. A hybrid economy, and we talk about what we've seen over the last several years. The idea that someone is working just for you from a national scope is the way things work and have worked for a long time. But this idea of the gig economy and where we are seeing project-based work, whether it be Uber and Lyft, or the idea of people picking up jobs here and there and then also working at different places and doing different things, we're expecting to see a dramatic increase. So, from the independent contractor perspective, the takeaway is the government took away its guidance, but there are still bases for people to bring claims in court. So make sure you are conducting, we talked about doing I-9 audits, we talked about doing pay audits. Make sure you are looking at who you are classifying as an independent contractor, and at the very least, running through the previous control test to make sure you're comfortable with that. So, we talked about independent contractors, let's talk about joint employment. From a joint employment perspective, this is where one company has the right to exert control over the employee of another company. Where did we see this? And you see the Browning-Ferris decision, which is National Labor Relations Board decision. But you see this all the time between franchisees and franchisors. You see this all the time between companies that share employees. We talked about leasing, employee leasing companies. There's a huge argument from the NLRB that there's joint employment there, that both parties have the right to exert control over the terms and condition of the employees. So Browning-Ferris came out in favor of finding joint employment. Then in 2016, the Department of Labor issued their joint employment guidance that took this very expansive view. Instead of control or direct control, they took this idea of indirect control. What does that mean? I have no idea what that means because it was a made-up term. What it has meant in practice so far is that they will argue that anybody who touches the employee can also be an employer of the employee. And they took a very aggressive stance on that. Then in July of 16, they changed the unionizing standard back to a previous very liberal standard in the Miller and Anderson decision that essentially said that the idea of joint employment can also be used to unionize workforces. So the reason we saw these NLRB decisions go crazy over the last several years is that unionized employee rates in this country are going down, down, down. And so it's where we see protected concerted activity occurring. It's where we see the idea of these decisions in joint employment. The NLRB wants to keep unionized workforces as a sector, as a part of our economy. And there are very few workforces now that consistently stay unionized. And that is the purpose of these decisions, is trying to undo that as the decrease continues every single year. So we saw, and I mentioned this earlier, but the Fourth Circuit adopted the standard that we saw from the National Labor Relations Board, the idea of this indirect control. In June, the joint employment guidance was withdrawn. In July, a bill was introduced to Congress to completely change the definition of joint employment. It hasn't been passed, but as proposed, and it has a ton of support right now, as proposed, it would affect NLRA cases and it would affect DOL, so Fair Labor Standards Act cases. Would make a huge difference in the amount of litigation we're seeing if that's passed. Browning-Ferris in December, so for those who don't understand or don't know about the National Labor Relations Board, it's a board of 5 when it is fully staffed and it is all politically appointed. Whoever is the political majority gets 3, and whoever is the political minority gets 2. So it's always a 3-2 when fully staffed. And then the National Labor Relations Board has a general counsel. So at this point, we have a 2-2 split, where we're not fully staffed. However, the tie goes to the chair. So right now, between the chair and the GC, we are dealing with, although a board that is still split, a board that's going to lean towards the right and towards the way that the right views these union-related issues. So we are seeing in December 2017, Browning-Ferris was simply overturned. The case was up on appeal in the federal circuit courts, and it got remanded. Since then, the unions have asked the federal courts to take it back. They've said it got remanded, but it got remanded before this happened, and the federal court should decide if that standard is right. I doubt they'll take it back, but it's entirely possible that that could occur. So the NLRB changes over the last few months. The general counsel's been in place for just a few months now. They were one of the later appointments that was approved by Congress. The changes are coming fast and furious, and from what we've seen, nothing is off limits. I would not be surprised to see the Supreme Court take up that joint employment case, where the Fourth Circuit issued a standard that is contrary to what we've seen from everywhere else. And again, we would expect to see over the next couple of years that some of these bills are likely to pass. All right, we talk about civility policies, and this is all based upon, we talked about protected concerted activity earlier. The idea of protected concerted activity is under the National Labor Relations Act, employees have the right to come together to engage in action that furthers benefits and conditions of employment. And so from a broad perspective, you might look at that and say, okay, well, they come together to change policies and procedures. But from a very micro view of it, we saw several decisions that affected common rules, things that you'd have in your handbook, that they said those handbook policies are against our rules. You know, we see civility rules, you know, the idea that you have to act like a decent human in the workplace. I said, well, maybe if you're engaging in concerted activity, you're acting like a jerk for the purposes of changing conditions in the workplace. Well, maybe that's protected. So without any action being taken on the handbook policies whatsoever, simply the policy itself led to lawsuits where they were saying the idea of civility rules are unlawful. And you know, this is direct quote from their policy. Employer expects all employees to behave in a professional manner to maintain a positive work environment. And in the T-Mobile case, they said, no, it's too broad. You can't say that. And most of us who practice employment law were looking around wondering, what? Why? Everyone has this policy. Well, you see, prior to the change in the GC of a few months ago, you see the very obvious problem with taking a position like that is that the EEOC tells you, you have to have those kinds of policies in place. That they are helpful ways to stop harassment and to stop discrimination in the workplace. Stop people, let them know it's not okay to act like a jerk. But the NLRA says it's allowed. So we saw recently, and there's some really bad examples, and I'll put some of these quickly. But these are examples of policies that were struck down as overbroad. Not posting items to their media accounts without permission. You know, what they said was, well, what if you were posting we should all get paid $2 more or $3 more? How should we deal with that? You know, that would make it illegal. You have to be more direct than that in your policy. The problem is your handbook isn't intended to cover every possible situation in detail. Your handbook is intended to give you general rules that can be worked amongst your whole workplace, and then if you have a situation, you're supposed to deal with each situation separately. So these were struck down. You see the Purple Communications case, whether unionized or not, you have to allow employees to use corporate email systems during non-work time to engage in concerted protected activity. Expect this to be overturned very soon. The Purple Communications decision was extremely controversial, and under a fully staffed National Labor Relations Board, I do not think it will stand. We saw confidentiality policies. How many folks, and you don't have to raise your hand, you can just nod if you don't want to raise your hand. How many folks have a policy in place that says you can't discuss your pay in the workplace? I mean, it's a common policy. A lot of people say, stop talking about your pay. It's none of anyone else's business but yourself. National Labor Relations Board has said that's unlawful. You cannot ban people from discussing their pay because they could be discussing their pay for the purposes of engaging in concerted activity in order to further our interests in getting more pay. I don't know that the idea that banning pay altogether is going to get overturned, pay discussions altogether, but I do think, first of all, this General Counsel memo has already been overturned, but I think the idea of protected concerted activity relating to pay discussions is going to be narrowed if the right case comes before the board. This is from a real case. I apologize if it is still vulgar even with the stars in it. However, the point of this slide is to let you know that there are decisions from the last year or two that have said that that is protected activity, and firing someone for engaging in this type of discussion is unlawful. There was another decision, and I won't go into too much detail about it because it's horrific. But it's discussions about comments that are made between striking employees and employees crossing the striking line. And essentially, horribly racist comments were made to an individual crossing the strike line to go work. And the decision to terminate that employer, to not rehire them after the strike was over, was viewed as retaliatory. And they said that even vulgar or obscene, it was protected. I would expect this type of decision to be very much an aberration moving forward. I do not think there's going to be, the problem with and the inherent issue with that kind of decision is the EEOC is going to tell you, if you allow that employee to come back, that you're potentially subjecting the employee who is hearing those comments to a hostile work environment. And you might be faced with an EEOC charge on one hand. And on the other hand, if you don't bring them back, the National Labor Relations Board is going to tell you you engaged in retaliation. So there's no way to win that case. And that is an inherent problem that I think you're not going to see these kinds of cases, particularly from the board. So they only get to federal court, just as a little way of background on procedure, they only get to federal court if the National Labor Relations Board rules something and someone appeals up to federal court. So if the board rules one way, you're not going to see a decision like that come down if it's the complete reverse. Those are going to be very uncommon. We talked about this already, but this was the National Labor Relations Board makeup. And this is, now it's 4, but it's soon to be in this direction. I have about, it looks like about 8 minutes left. So I know there were lots of questions throughout this. I wanted to save at least 10 minutes for questions, so I failed by about 2 minutes, I think. But I'd be happy to take any questions you may have, whether it's about stuff that is in my presentation or stuff that you're dealing with. As I like to say during presentations, people often are hesitant to call their lawyers because of what I call fear of billable hour. This is one of those moments where you don't have that. I'd be happy to answer some questions.
A question that comes up quite often about the rules for exempt employees, and when you hire somebody at a salary in an exempt position, when you do offer policy of paid time off, when you run out of paid time off, you take off. Can you just give me some insight on whether you're obligated to pay that yearly salary that you committed to, irrespective, or there's a PTO policy in place, how that may change that?
Sure. So the question is, how does the use of a PTO policy affect your payment when people are absent and when they exhaust their PTO, when you're treating them as exempt under the Fair Labor Standards Act? Now, I can't tell you in, what state are you in?
New Jersey.
New Jersey. So I can't tell you if New Jersey's particular wage laws change this, but I don't believe they do. The general law, and so this is all about deductions from salaries and what is or is not permitted. The law says if you have a bona fide PTO policy, which means they earn PTO, you take it away, you can take away PTO in both full day and partial day absences for employees that are absent for personal reasons. The problem becomes when they exhaust PTO, how do you deal with it? And so if someone has fully exhausted PTO but misses a day for a personal reason, completely personal, you can deduct for that one day for a personal reason. However, if it's for sickness, disability, or some other, and Fair Labor Standards, or Family Medical Leave Act and Fair Labor Standards Act have a working together provision that allow you to take away partial absences for that. But if it's not FMLA leave, then it's only if they're gone for a full week. So if it's a disciplinary related suspension, if it is short-term medical leave, if it's something like partial day absences, you do have to pay the full salary for that week. If it is a personal reason why they're gone, you do not. And so the question, if they're out of PTO, but you said fine, you can go take your grandma to the doctor. You do not have to pay for that day, as long as they do absolutely no work in that day. if
But
they
if
work.
you suspend them, you gotta pay them?
It depends if it's a severe violation of a safety or company policy, you do not. But the only way to guarantee you don't have to pay a suspended employee, because there's a ton of fights over what is a severe safety or company policy violation, is to suspend them for a full week. And when they're gone for a full week and perform no work, you do not have to pay them regardless. But if you suspend them for a day, yes, it's a paid suspension, unless it is the severe violation. And that's why most people, you see a ton of week-long suspensions, and it sounds really harsh, but they're doing it for FLSA reasons, because a one-day suspension where you're paying them is not really a suspension, that's a vacation.
We have a company in our area that advertises for drivers, and they're gonna pay them whatever the rate is. But the way it reads, it's as if they are a subcontractor, I might even say that, but they also have to supply insurance for the company's trucks
Okay.
that they're driving. That seems like that ought to be illegal to me, but I don't know.
They're trying, so it sounds like they're, essentially it sounds like they're trying to set up independent contractor relationships with drivers.
Yes.
It's very difficult to do. It's very difficult to have somebody that drives primarily for you, and that you set when they drive, how they drive. You know, it's the difference between Uber, where they can pick up any job they want, and even Uber's being sued and the people are claiming they're employees.
So how's RPS doing that?
I'm sorry?
How is Federal Express doing that with their ground service?
All I'll say is Federal Express has been sued a lot about that. I won't go into too much more about that, because there are some active litigation lawsuits about that.
Yeah, 'cause they're all classified as subcontractors.
Correct, and there are ways to do it, and there are attempts to do it. There's a lot of models that are continually getting tested, and that happens to be one of them. But there's not a guaranteed way to do it. Essentially, if the individual has the right to decide when they pick up, how they pick up, what routes they take, and what that model that you're discussing is ownership of routes, and they really have set up a model now that relates to ownership of routes. That's totally different than the idea of you're gonna drive for me, and here's what I need you to take, and you're taking this on Monday, this on Tuesday, this on Wednesday, they work only for you. That sounds a whole lot more like an employee. But it is very, very fact-based, and it is the problem with setting up relationships like that is if it's one person, if you're wrong, it's no big deal. If it's 20 people or 50 people or thousands of people, if you're wrong, it's a class action lawsuit and the damages are massive. So that's where you gotta be right on the front. So here's my view of that. The question is, you know, conduct rules and no profanity in the workplace rules. Is it legal? So under the prior NLRB, it's possible that could have been challenged. Under the current NLRB, I wouldn't expect a very strong challenge to that. But from all of the rules, and you saw a lot of things that got struck down by the NLRB as improper handbook policies, I still tell my clients, you have to use common sense. And if you have a problem with profanity in the workplace, and it's led to whether it's harassment, discrimination, retaliation type claims, you've got to ban it and you run the risk. And if it's what works best for your workplace, as long as you enforce the policy. The problem about having a policy you don't enforce is somebody's going to sue you the one time you enforce it. So if you have a no profanity in the workplace policy, that's great. But if everybody is swearing all day long and then you're like, oh, that's how I'm getting rid of the guy I've been trying to get rid of for the last year, I promise he's suing you when you get rid of him. Yep.
Can I ask about just a question about GPS tracking in terms, so we pay drivers at night, they're driving, we track via GPS. We have the ability to see if they're on seat, off seat, all of that kind of stuff.
Mhm.
Is there legality to pull time away when we see things on GPS? Is there some sort of basis in legality for that?
Sure, so the question relates to GPS tracking,
Yeah.
and if you feel like somebody wasn't working
Right,
based upon
right.
the GPS tracking,
Yep.
can you pull the time away?
Yeah.
And so the answer to that is kind of twofold and a little complicated, but number one is from the GPS tracking standpoint, make sure you're getting acknowledgments from your drivers. There really shouldn't be an invasion of privacy claim anywhere, but we still see them being brought, which is why you want to have the acknowledgement on the front end. And that acknowledgement should say, I understand that the employer may use this information to review whether I'm actually working during the hours that I claim I am. And if it creates a situation where you think someone is lying in their time, the way you want to do that is, we have what I call the pay and punish rule, which is if somebody works unauthorized overtime or claims to work time and you don't think it's accurate, you can punish them for violating your policies and still pay them and then fire them if they do it again. And the second way you can approach that, and I have no problem with this, is to go directly to the employee, lay out the evidence you have, explain what you've seen, and say, look, if you tell me that this is wrong, I can tell you this better not happen again. And I'm going to pay it for you this one time, but I want you to know we're looking at it. But if you tell me and be honest about it, that this is in fact what happened and your time card is incorrect, I'm not going to hold it against you. Just be careful about it moving forward.
So you're setting a precedence at
Yeah.
that point, right?
Yeah, and in that situation, I think you'll find most of the employees will be like, yeah, I forgot to clock out for that lunch. It wasn't on my time card, but you're right, I wasn't there. But keep in mind, short breaks, something like 10 or 15 minutes, really 10 minutes is the area we see it a lot, are still compensable. So you can't just take away 10-minute breaks just because someone's not working. DOL would be all over that. Yep. One more question? I think we got time for one more.
Tom, I know you can't answer in full, but do you have any suggestions on the best way to make sure we're staying in compliance with prevailing wage laws? They seem to be really convoluted and complicated, especially when you're working multiple shifts and when one's starting and one's stopping and when those various rates kick in.
Yeah, so the question is best advice on prevailing wages, and my best advice for compliance is to have someone at your office solely assigned to understanding and working with your attorney on prevailing wage rate laws. It's incredibly complicated, and particularly when they make changes to it. You see, and I don't know if you're operating in multiple states, but you see Davis-Bacon Act rules. You also see what we call mini Davis-Bacon Act rules, which are when states decide they want their own version of Davis-Bacon Act, and they make it even more onerous, and they create separate prevailing wage rates. So you might have essentially a position where you know state by state how it should be applied based on federal guidelines, and then you have changes statewide, or even cities and localities, that make it incredibly complex. The best thing to do is have somebody, honestly, there's a ton of really good trainings out there on it. Have one person assigned to it, send them to a training, and make them your responsible prevailing wage, guru. And the questions can get complex, and just have a good lawyer